They had fire insurance. They had documented losses. They filed the claims. Every single claim was denied. And the mechanism they used to deny those claims in 1921, the same mechanism is sitting inside your employer's HR policy right now. Today I want to walk you through what happened to Black Wall Street after the fire. Not just the fire itself, and show you exactly how the institutional playbook that destroyed the insurance claims of over 1,400 black families in Tulsa, Oklahoma, is the same playbook being run against discrimination claims in 2026. This is the pattern. Let's go. Before we talk about insurance claims, we need to understand what was actually destroyed. The Greenwood District in Tulsa, Oklahoma was not just a black neighborhood. It was one of the most concentrated centers of black wealth in American history. 190 black-owned businesses, black hospitals and medical facilities serving the entire community, law offices, hotels, banks, grocery stores, professional services. The area had earned the name Black Wall Street, not as a compliment from outsiders, but as an accurate description of what had been built there by people who had been legally excluded from the white economy and built their own. This is important context. These were not poor people. These were property people. People who owned businesses with inventory. People who owned buildings with assessed values. People who held fire insurance policies from legitimate insurance companies. On May 30th, 1921, a 19-year-old black shoe shiner named Dick Rowland entered an elevator in downtown Tulsa. A white woman named Sarah Page was the operator. What happened in that elevator was likely nothing. Later research suggests Rowland stumbled and grabbed the elevator door, but the Tulsa Tribune ran a front-page story suggesting assault. By the evening of May 31st, a white mob had assembled outside the courthouse where Rowland was being held. Black World War I veterans arrived to protect him. A shot was fired, and within hours the Greenwood District was under coordinated attack. The Department of Justice reviewed this event in January 2025 and described it as and I want to be precise here because this is a primary source, quote, coordinated military-style attack conducted by a white mob of over 10,000 people, 35 city blocks, destroyed in 16 hours. Official records listed 36 dead, but historians and the 2001 Oklahoma Commission put the true number of black residents killed at somewhere between 150 and 300. The gap between what was officially recorded and what actually happened is itself part of the story. Thousands arrested, thousands more made homeless overnight. 1,256 residences destroyed. Black hospitals and medical facilities serving Greenwood gone. And then the people who had just watched everything they built get burned to the ground sat down and filed their insurance claim because they had policies, because they had paid their premiums, because that is what insurance is for. 1,400 claims filed, over $4 million in documented property losses in 1921 dollars, equivalent to somewhere between $29 and $41 million today. Every claim denied. Not because the losses weren't real, not because the policies weren't valid, because of two words: riot clause. Most fire insurance policies of that era contained a riot exclusion clause, a standard provision. The city of Tulsa had officially classified the event as a riot. The classification was specifically designed to prevent insurance companies from having to pay. The naming of the event was itself a legal instrument. Call it a riot and the riot clause applies. Call it what it actually was, a coordinated military-style attack, and the riot clause doesn't apply. They chose the word that made the claims deniable. Think about what that means. The destruction was real, but the institution controlled the language that determined whether any of that mattered legally. And just so we are clear about how durable this institutional protection was, in June 2024, the Oklahoma Supreme Court dismissed the lawsuit brought by the last two living survivors, Viola Fletcher, age 110, Leslie Benningfield Randall, age 110. Both were there when Black Wall Street burned. The court acknowledged the grievance was legitimate. It dismissed the case anyway. Harvard's analysis is precise. The failure to compensate wasn't just about 1921. It was about every generation since, the generational wealth that would have been built. There is still no hospital in North Tulsa today. So that's 101 years that hospital has never been rebuilt. That is what the riot clause cost. Now, I want you to sit with what just happened in that story for a moment before I connect it to your situation. The institution knew the policy language. The claimants knew they had losses. The gap between those two knowledge bases was the mechanism of the denial. That is the same gap operating in your workplace discrimination claim right now. Let me show you exactly how. When your employer receives notice of a discrimination claim, the first thing their legal team does is not assess whether the discrimination happened. They assess what can be challenged procedurally. Did the employee file within the 180-day EEOC deadline? Did they check the right box on the charge form? Did they name the right respondent? Did they exhaust internal remedies first? Is the evidence submitted in an admissible format? These are the 2026 version of the riot clause. The mechanism is identical. The institution uses complexity, specific language, specific exclusions to create a gap between what you are owed and what you can collect. Here's where it gets specific to what Force Multiplier teaches. The reason the evidence hierarchy framework starts with Tier 1 evidence is about procedural survivability. Tier 1 evidence creates a factual record so clear and so specific that procedural objections to how it was filed don't eliminate its evidentiary weight. When you have a recording of your manager saying, "We need to replace her before the baby comes," the procedural argument of which box you checked on the EEOC form becomes significantly less powerful. The Greenwood residents with the most detailed property inventories, formal business records, property deeds, had the strongest claims. Same principle, different century. Let me show you what this looks like in practice. Sarah had worked at a technology company for 6 years. Strong performance reviews, 3 promotions. In January 2024, she was terminated. The stated reason? Restructuring. The real reason? She had filed an internal pay equity complaint 3 weeks earlier. Sarah filed an EEOC charge. Her employer's first response was not to address the merit of the discrimination claim. Their first response was procedural. They argued Sarah failed to properly exhaust internal grievance procedures. They argued she had not checked the correct box for retaliation. Sarah's attorney recommended settling for $22,000. But here's what the attorney had not fully assessed. Sarah had 4 years of strong performance reviews. She had a documented timeline, 21 days from complaint to termination, Tier 2 evidence. And she had one additional piece, a text message from her manager the week before termination. Let's talk offline about the restructuring. I want to protect you. Tier 1 evidence. Overall grade, B+. Now let's run settlement math. Base damages, $97,000. Evidence multiplier, 1.8 times. Employer multiplier, 1.6 times. 2 agency filing. Total exposure, approximately $279,000. Add defense costs, conservative estimate, $140,000. Total cost to fight, $419,000. The recommendation to settle for $22,000 was based on Sarah's perceived vulnerability. But the Tier 1 evidence, that text message, survived every procedural challenge. Settlement reached $210,000. The Harvard analysis of the Tulsa massacre reaches a conclusion that applies well beyond 1921. The failure to provide reparations conveyed an implicit message that the violence would be condoned. The information asymmetry that destroyed the Greenwood insurance claims was not accidental. The riot classification was deliberate. The riot clause was standard. The combination was catastrophic. 1,400 families, $4 million in documented losses, 0 compensation. Not because the law failed them, because the institution knew the law better than they did. In 2026, that pattern has not ended. It has been refined. The procedural objection replaced the riot clause. The PIP replaced the hostile environment. The restructuring replaced the termination. The names changed. The mechanism did not. The evidence hierarchy course exists because the only counter to a mechanism built on information asymmetry is closing that information asymmetry permanently. That is the pattern. If you are currently experiencing discrimination, retaliation, or wage theft, and you want to understand how to build evidence that survives procedural challenge, the course is linked below. $97. The Greenwood residents pay for their insurance policies and never receive what those policies promised. You pay for your legal rights through your taxes every year. The question is whether you know how to collect.